As you work on creating a robust long-term estate plan to assure for a smooth succession of wealth to your family members and loved ones, a natural question might be, what exactly is needed to be wrapped under a trust, and what can be taken care of simply by designating the proper beneficiaries? It can be a bit of a confusing process to sort through all the paperwork. To help answer these types of questions, we're fortunate to have with us today Kern Singh. He's managing partner and a founding partner of the Singh Law Firm, which has offices in both Northern and Southern California. He's also a member of IFA's National Referral Network for Estate Planning Attorneys. Hi, Kern. Thanks for taking some time today to discuss these issues with us.
Thank you so much, Murray. I appreciate the opportunity today. And, for all of those who are joining or watching, welcome.
Thank you. In your firm's list of action items after a trust is created for a client, you break out different actions required by banks with physical locations as opposed to those that don't have physical locations. Why is that?
Yeah, great question, Murray. The reason that we break it up as such is that you got to deal with those various institutions differently. So if there's an financial institution that has a physical presence, a brick and mortar shop that you can walk into, a Wells Fargo, Bank of America, Chase. So think of those types of institutions. Well, it's simpler for you as the client, to go into the bank with your actual documents and sit with a banker and have them do the paperwork to transfer your probate triggering assets into the trust. So your checking, your savings, if you have any, taxable trading accounts with them, you'll want to change the title of those accounts into the name of the trust. Now, if you bank at an institution that pretty much has an online presence only. Now think of American Express, Vanguard, you've got Fidelity. So these online financial institutions that don't have physical presence, you're going to want to call their 1-800 number. You're essentially following the same set of rules that you would when you'd go physically in, outside of there's not a person helping you fill out the paperwork. So in essence, the online guys call their 1-800 number, speak to the representative, tell them that you have a trust, you want to transfer the accounts held with their institution into the name of your trust, and either they will direct you to their website where you can download their trust transfer form, or they'll go ahead and email it to you. Either way, you need to get your hands on those forms and then fill them out and then submit it back to them. And in essence, you're going to then have transfer those accounts into the name of the trust. So that's why we break it down separately, because there's a different kind of a path that you get to the same result ultimately. But we do our best to make sure that the client knows what to expect and knows how to get there, as opposed to them kind of just figuring out what they should do on their own and going online and getting inaccurate information.
Sure. And you also specify which counts you can list family members, spouses, siblings, whatever, as primary beneficiaries versus wrapping the accounts into a trust, correct?
Great question here again, Murray. Yes, and this is kind of the touchy area, is that you have to look at your asset classes a certain way and the type of asset it is, and then determine whether this asset needs to go into the trust by title, or should you look at the beneficiary designations and accordingly work that out. Now, when you're talking about probate triggering assets, these are assets that pretty much everybody has. And if we passed and didn't have a trust, those assets would cause our estate to go through probate. Those assets need to be changed by title into the name of your trust. And those are any real estate holdings, your typical checking, savings, and your taxable trading accounts. When you have retirement accounts, these are your typical 401ks, IRAs, SEPs, so any sort of a tax deferred or tax sheltered account, you do not put those in the trust. Why? Because the government, IRS, Uncle Sam is our partner on those accounts. So they're basically saying, look, even though you may have 100K in your retirement account, that's not all yours. Some of it's mine, and I'm going to allow you to go ahead and keep that money tax sheltered until 65. And if you decide to pull it out before, let's go ahead and penalize you, take your taxes out, because they want to ultimately get paid. So they want a human on the other side as a beneficiary on retirement accounts, because the IRS allows that human beneficiary to open up an inherited IRA for themselves, so that the money goes from your retirement account to that inherited IRA account, and that jump over is not a taxable event. Whereas if you listed a trust as a beneficiary on your retirement accounts, your trust does not have the ability to open up an inherited IRA. Therefore, that money would be taxed right away. So it's a tax issue when it comes to retirement accounts. Now, life insurance, there's no taxation issues. There's also really no title on life insurance. It's not a probate triggering asset. So then we look at the beneficiary designations on our life insurance, whether you have it through your employer's benefit package through work or you privately purchased it. Your primary beneficiary, if you're married, should be your spouse. And then the contingent beneficiary, the secondary beneficiary, should be your trust. And if you're not married, you're single, then your primary beneficiary would be your trust. The idea here is that if you end up listing just your kids as beneficiaries in the first or secondary position, and God forbid something happens to you and something happened to that child, or let's say you have two kids and something happened to that one child, does their share end up in probate? Does their share go to their kids? Does their share go to the other beneficiaries? You don't control that. The beneficiary designations and the fine print with your life insurance company dictates what happens. But what you need to do is when you have the trust set up, your trust is going to dictate and handle all those various contingencies. So why not control it through your document? Why let the bank control that? So that's kind of the variations on how we would handle which assets go into the trust, beneficiary designations on how to handle that. There's a strategic and logical way to handle it. And you definitely want to just follow that format.
Okay. And what about safety deposit boxes, credit cards, other types of things that you may or may not have through a bank?
So credit cards are not assets. They're not probate triggering assets. A credit card is essentially credit or a loan essentially given to you. Those don't need to be placed into the trust. But automobiles, planes, boats, tangible items we have in our house, furniture, bedding, computers, other types of items in your house also do not go through probate. Typically, your trust is already going to have a statement in it that says that even my personal belongings go equally to my kids, or however you want your distribution to be. But with automobiles, planes, and boats and whatnot, they do have title. They don't go through probate. What simply happens there is that your trustee would take your death certificate, and if it's an automobile, be able to go to the DMV. DMV has paperwork. If it's a plane, they'll deal with the FAA. If it's a boat, they'll either deal with the DMV if it's a lake boat or the Coast Guard for titling purposes. But at the end of the day, we've never recommended putting any of these types of assets in a trust. I think we did one time, and that was because the client had a collector's item as far as an automobile goes, and it kept going up in price. So, but in general, you want to stick through, again, going back to that drawing board, stick to the items that are probate triggering assets and itemize those assets. And then the chart that we typically give our clients, those assets fall into the various buckets, and then you're instructed as to what you need to do there.
Okay. And credit cards and insurance policies, those don't go in, correct?
Yeah, credit cards do not go into the trust. Now, with insurance policies, if you have real estate, your real estate is an asset that does trigger probate. It is going to be in the name of the trust. And what we recommend is that you need to contact your liability carrier, your insurance carrier for liability purposes on the house, and have them add your revocable trust as an additional insured or interested party on your policy. And this is with your insurance. The idea here and the logic behind that is that you're trying to keep your insurance carrier honest. If you don't take that step and someone comes to your home, they slip and fall, and there's a judgment against you to pay that individual for their damages, and you go to your insurance company, say, insurance company, hey, it's within the limits, can you pay out? Insurance company potentially has an out here to say, hey, look, you know what? The house was titled in the name of the trust. We're actually only insuring you as individuals, not your trust. We're not paying. So by just taking that little extra step by adding your trust as an additional insurer, you're actually keeping your own insurance company honest.
Thank you, Kern, for taking the time today.
It is my pleasure. Thank you so much, Murray, for having me here. And if anyone ever has questions, let us know. We're here to help.